Thank you for coming to the press conference by the Acting Chief Executive, Mr. Donald Tsang. We are providing simultaneous interpretation service in Cantonese, English, and Putonghua. And accompanying Mr. Tsang at today's press conference is the Secretary for Justice, Ms. Eslie LEUNG, and also Mr. Clement Mack, Permanent Secretary for Constitutional Affairs. May I first invite Mr. Tsang to say a few words. Good afternoon. Just now at the Legislative Council, I explained in detail the rationale for requesting the NPC Standing Committee to interpret Article 53 of the Basic Law concerning the term of the office of the new Chief Executive, so I'm not going to repeat myself here. Suffice it to say that this is indeed a tough decision. I understand some members of the public might believe there is a need for interpretation, though they could not likely accept the decision to seek an interpretation. Now, I must say this. This is a decision that I made, and I have to take full responsibility for it. And also, on the 10th of July this year, I must make sure that the Chief Executive election shall be conducted with a firm legal basis in order to meet the public aspiration. Now, as I made this decision in the process, I did encounter some difficulties because there are divergent views in the community about the term of office of the new Chief Executive. And there are, in fact, some individuals in the community who have applied for judicial review. So that's why it is possible that the election of the Chief Executive could not be held as scheduled on the 10th of July. So faced with this problem, faced with a tight time frame, and also faced with the need for the SAR government to operate smoothly, we have but one alternative left, that is to seek an interpretation of the basic law by the NPC Standing Committee. And we believe that is the only alternative, and it is also in line with the interest of Hong Kong. It is also legitimate. Thank you. That's all I would say for now. Now the floor is open for questions. Please first identify yourself, give us your name and your agency first before you ask the question, and please cooperate and limit yourself to just one question at a time.
Yeah, I think, yeah.
Oh, okay. Mr. Zhang, my question to you is...
Can you identify yourself and the organization?
Eric Finney, TVB News. Mr. Zhang, there is speculation that this whole issue, the two-year term, the possible interpretation, the legal challenges, all revolves around the issue that Beijing doesn't trust you with a full 5-year term. Do you feel any pressure, since you are a holdover from the British system, to prove your patriotism to Beijing?
I think it's excessive speculation over this issue. We have one problem to resolve, and that is we have to hold the election in accordance with the basic law, in accordance with our domestic legislation on the 10th of July. And as regards the term, we have done enormous research on this, including the legislative intent. And we have come to the conclusion, using our own legal tradition, that the term of office of the new Chief Executive elected in these circumstances should be remainder of Mr. Tong's original term, that is 2 years. And for this reason, we are now seeking legislation, but unfortunately the problem arises over the judicial review, which is now underway, and a time constraint within which we must work, and we need interpretation from the NPC Standing Committee. I think any other suggestions or any speculation is quite unnecessary. We do have a constitutional duty to perform, and we need to do it properly. This is what the wish of Hong Kong people.
Okay.
The back there, last row, the lady. And then this lady. Yes, I'm from RTHK. In the basic law, there is no provision for the Hong Kong SAR government to request an interpretation from the MPCSC. So is this procedurally sound? Is it a backdoor approach here? Well, this is normal procedure, and this is necessary. And it is the duty of the SAR government, in particular the duty of the Chief Executive, because Article 43 of the Basic Law states very clearly that the Chief Executive shall be responsible for affairs of the SAR government. And Article 48(2) states very clearly that the Chief Executive has the responsibility to implement the Basic Law. Now, as we implement Article 53 of the Basic Law, that is to conduct a by-election as the post of the Chief Executive becomes vacant, we have encountered a difficulty that could not be resolved. So we need the assistance of the MPCSC to interpret the Basic Law. This is to dispel the doubts and concerns of the people of Hong Kong. So that's why we have taken this step, and this is entirely legitimate and procedurally sound. And if we've actually done so before. Yes, the lady in the grey suit. Now, all along, the central government does not wish to resort to interpretation. This will be the last resort. So now the SAR government has to resort to interpretation basically also because someone is trying to create problems and troubles for the SAR government. Now, in accordance with the procedure of the Basic Law and local legislation, we've come to this decision. But then we've also come to the conclusion that this is difficulty that we face, which cannot be resolved entirely on our own. And Article 158 of Basic Law does provide for a mechanism for the MPC Standing Committee to interpret the Basic Law. So I'm sure the central government fully understands that. And I hope you also understand that the Hong Kong people do not wish to see interpretation of Basic Law, and the SAR government only resort to this means as the last resort. So I'm sure the central government fully understands that, and I'm sure the central government shares our same goal. That is, a new chief executive will be elected smoothly on the 10th of July. This is to ensure the economic prosperity and social stability of Hong Kong. So to achieve that, we have no choice but to trouble the MPCSC to give an interpretation of Article 53 of the Basic Law.
And
Jan Höhn, Handelszeitung. Mr. Tang, the American system is working with the president in charge, and if he is having some trouble, the vice president is automatically the one who is filling up the time remaining. Do you think it's necessary to amend the Basic Law that way, as it seems to be working quite well in other countries? And to what extent do you think this kind of amendment business is feasible with, I don't know, perhaps not only the central government, but the other party which was also on the table, Great Britain?
Well, I'm sure every territory has its own system to deal with the situation of the resignation of the chief executive or president or prime minister. The Hong Kong arrangements is set out in the Basic Law. I'm not saying it is superior to the American system, but it is there is a provision for it. The problem we face now is that there is a dispute over what it means. So although the original legislative intent is quite clear, and the matter could be resolved as we have proposed by an interpretation by the National People's Congress Standing Committee.
Ms. Kong, Mr. Zhang, you have repeatedly indicated that you're working on a tight schedule. Does it mean that you do not believe that the court will be able to deal with this matter expeditiously, and that is why the SARG has to deal with it? And since some members of the public have already applied for judicial review, how may you respect the public's right to exercise this prerogative? Are you ruling out the option for them to exercise the right of judicial review? I fully believe that our court will deal with these constitutional matters relating to the election of the CE in an expeditious manner. But there is a limit to what the court can do. because we understand that this issue is about the something which involves the relationship between the SARG and the central authority. Furthermore, the appointment of the CE is the responsibility of the central people's authorities. So therefore, we've come to the conclusion that eventually we have to refer the matter to the MPCSC. However, in the process, we must understand that since someone has already applied to the Court of First Instance for judicial review, and this has to go through the Court of Appeal and the CFA before we can go to the MPCSC, that process will take time. And the MPCSC will only meet in April. The meeting for June will be too late for it to deal with this matter, because we will not be able to carry out our work for the election of the CE. Therefore, if we will make use of the slot in April for the MPCSC meeting, we cannot force the court to go through so many procedures within such a short period of time, namely the preliminary hearing, going to the Court of Appeal, the CFA, and coming to a decision before taking the matter to the MPCSC. Furthermore, for the right of any member of the public to seek judicial review, that has not been affected. Anyone can still continue to do that according to the judicial procedures. All we hope is that when this matter is eventually dealt with, there will be an authoritative and clear interpretation of the rules so that a clear decision can be made. Wong Kok Kay and Hong Yi Man. Wong Kok Kay. Mr. Zhang, the Bar Association and the could you first identify yourself? My name is Law from the Economic Journal. The Bar Association and the Article 45 group have indicated that the judicial review will not affect the election. The two can proceed in tandem. But this time you eventually decided to seek for interpretation from the MPCSC. Does it mean that you have no confidence to leave the matter to the Court of Hong Kong to decide? The Secretary of Justice have come to the conclusion, according to the legal advice he obtained from mainland. Is it the case that such advice will not stand the legal challenge in Hong Kong? I've already explained that ultimately the matter has to be dealt with by way of decision of the MPCSC. The important issue is the question of time. Furthermore, as far as the whole matter is concerned, it's not as simple as it appears. Our recent experience concerning judicial review shows that there could be many uncertainties. After going through the process, and the method of coming to a decision will affect the electoral process, and we believe that our view may be different from that of some in the legal profession. So once the judicial process is started, we cannot estimate how long it will take, and we cannot anticipate what will be the areas of contention and what the final ruling will be. So each ruling will have an effect on the electoral procedure. I therefore believe that the risks are quite high, and that's why I've come to decision to adopt the present option, that is to seek the MPCSC's to make an interpretation. Perhaps the Secretary of Justice can also further elaborate. Whether it's the State Council asking the MPC to interpret the basic law, or whether or not our court will request for the MPCSC to interpret the basic law, eventually it is still the decision of the MPCSC as to how the basic law should be interpreted and whether or not the decision is retrospective in effect. Actually, for the SARG to ask the State Council to request the MPCSC to make a legal interpretation, compared with our court asking the MPCSC to make interpretation, there is no difference, basically. Secondly, we understand that the process of judicial review concerns a very special type of litigation, and the court will have the discretion to deal with it. Whether or not the court exercise that prerogative is entirely up to the court. For example, if the court is of the opinion that it's not within its jurisdiction, then even if the two parties to the litigation claims that the court has the jurisdiction, the court may still not agree. Secondly, the person applying for judicial review if he would have to have sufficient interest in the proceeding before his review is allowed. The court has the power to revoke his application for judicial review. However, the court may not need to make a decision concerning the term of the CE. All the court may say is that the court does not, the applicant for judicial review doesn't have any interest at stake, and then later on another person may apply for another round of judicial review. Furthermore, the court may also say that this is a matter which involves a piece of legislation which have not yet been enacted, and therefore it should not be up to the court to decide whether or not it's against the basic law, and that the prerogative should lie with the Legislative Council. And that is why the court will not make a ruling on this matter. It's equally possible. I understand that there are two applications for judicial review in hand. I'm not commenting on these two applications. I'm just talking about the situation as reflected in general law. As to whether or not judicial review can really help us resolve this problem, there are some doubts. The court may not entertain the case or may not come to decision, but it doesn't mean that this is because the court has any view on the terms of the chief executive. Hong Yi-man. I'm from TVB. Mr. Zhang, you're now you are now seeking the MPCSC to interpret whether or not your term should be 2 or 5 years, but you've not also clarified the issue as to whether or not the new CE term can be for 7 years or 12 years. For the candidates for the by-election, do you think this is fair? And furthermore, it is rumored that you are one of the likely candidate in the by-election. Would you also remind the MPCSC that in seeking for an interpretation, you might have a conflict of interest yourself? I don't think you should speculate that I will be standing for election. We have to deal with this pressing issue at hand. It is exactly because we believe that this is a very serious decision for us to ask for an MPCSC interpretation. This is because we have no other options but to ask for an interpretation from the MPCSC. I believe that what I need to do now is to seek an interpretation concerning the term of the CE. Other less pressing issues can be dealt with later. Of course, each decision may give rise to other problems or repercussions, and we need to conduct extensive consultation in Hong Kong. We have to come to a position before we proceed. I'm sure there are different options to deal with the residual issues, and we will not need to ask for the MPCSC to make an interpretation. What we need to handle now is the election for the CE on July the 10th. For the less pressing issues, we'll deal with them later on. Furthermore, each time we ask for an interpretation from the MPCSC, we have to consider carefully whether or not this is the only option. Jimmy, followed by Lau Kwong. I'm from the SAMP. Many people have asked, or have you considered the option for the MPCSC to take the initiative to make an interpretation? And would there be similar arrangements this time?
Well, I think it really depends on the cost of the issue. Well, now we all like to see this new CE to be elected on the 10th of July. So now the problem arises within Hong Kong. As we make the preparation, we found that there could be judicial reviews and other problems. In particular, on that provision, there are different interpretations among people of Hong Kong, and that's led to problems. And these are problems arising from within Hong Kong. So that's why Hong Kong's duty to propose means to address the problem. And I think that is squarely the duty of the Chief Executive in accordance with Article 48(2) of the Basic Law. Now, for remaining issues, they might be resolved later. So does it mean that in future there could be another interpretation of all the remaining issues in one go? Well, I must reiterate once again, interpretation of the Basic Law is the last resort when there are no other alternatives. Now, for all remaining issues, there could be other ways to deal with that. What is most important is that there is no urgency as the election on the 10th of July. So that's why we need more to look into that issues in more depth, and we also need to consult Hong Kong people. We also need to listen to legal opinions of the mainland experts before we decide what to do next. Now, I understand there are many remaining issues, but these are not urgent remaining issues, and interpretation of the basic law may not be the only means to deal with those issues. Francis, and then the one in blue and white.
You referred it again and again to pressing matters and less pressing matters. What is it about the length of term that is so pressing that it must be resolved before July 10th, but other matters can wait until later on? Why can't, as the Honourable Margaret Ng put it to you, why can't you proceed with the procedures for the election and allow the question of the length of term to be resolved by the courts subsequently? What makes it so urgent?
I believe it is irresponsible on the part of the administration to ask people to come for the election without telling them how long they may serve. It is absolutely unfair to the candidates and to the people involved. And what happened afterwards if someone is elected on the understanding that he's going to serve X years and suddenly it becomes Y year? The electors may have very strong grounds for judicial review to overturn that decision, and the person involved is equally aggrieved if he's going to serve either a shorter or longer term. In any case, to me, it is a matter of utter irresponsibility on the part of the administration to go forward for election without stipulating quite clearly and resolving the question of term.
Follow that, please, Chief Secretary. Wouldn't the unreasonableness, if any, to an individual be greatly outweighed by the benefit of the community not to have to go through something that you yourself say you really would prefer not to?
Yes, but we must not forget that the power of interpretation and a machinery and a system of interpretation to resolve disputes of this kind is enshrined in a constitutional document, apparently in Article 158 of the Basic Law. It is part of a mechanism to specifically resolve questions of this kind. And it is a time to invoke the mechanism, however unpalatable it may be to some people.
Okay, 呢位女士。
鳳凰衛視嘅蕭麗，我想問。
Phoenix TV. Now, this is the third interpretation by the NPCSC. This afternoon, you said there's no need to amend the basic law in the short run, but what if in the long run, you might consider amending basic law to avoid similar problems? Well, I don't have that intention now. I can only reiterate this. Now, we asked the State Council to request to the NPCSC to interpret the basic law. This is a very serious and very important decision. There has to be absolute need for us to do before we do that. As for other issues, if there should be an interpretation of them at the same time, I don't think is appropriate. We should have adequate time to consider the other follow-up issues, and then we come to a proposal that is acceptable to most. Mr. Powell, and then Ms. Lee. Yes, I'm from Hong Kong Economic Journal, Powell Wing Kin. Now, some members of the public have suggested there could be another scenario that might disrupt the CE election. Now, the law states that, let's say, apart from you, let's say James Tan or Miss Emily Lau might have become deceased or bankrupt or seriously indisposed, and then the whole election will have to start all over again. So could that lead to a constitutional crisis? Well, all these are really speculative issues. I'm sure whenever any problems arise, then in accordance with basic law and the Chief Executive Election Ordinance, we will deal with these scenarios accordingly. But I can say for sure, at this point, there is one issue we really must resolve, and that is the term of office. And once we have that resolved, then at least we could start our work on the July 10th election. As for remaining issues, they could be dealt with in other ways. Now, this could happen, and it's possible you could not handle it. No, definitely, it can be dealt with. But it depends on the exact scenario then, and then we'll decide on a means to deal with that. I'm sure in the basic law, in our local legislation, all these scenarios have been adequately catered for, and if scenarios should arise, there will be a means to deal with that. Lee Pik-Kwan. Now you said if you don't state clearly now whether the term is 2 years or 5 years is not responsible, then I don't understand how come you don't clarify at this point whether the longest term is 7 years or 12 years. Because if you don't make that clear now, is it also responsible? Because some people might wonder, or people who might want to contend might not be sure how long they could serve at the maximum. And it's still possible someone might apply for a judicial review. It could still abort the election. So why don't you do it in one go instead? Why do you want to wait for a fourth NPC interpretation? Now, I don't want to say that we are going to have another interpretation, but I think what is important is for the person who runs for the election knows exactly how long the term of office is. But for the other issues, well, they relate to other provisions. Now, we asked the election committee to elect a chief executive, and it's on the basis of a 2-year term, and there's no misleading whatsoever there. And on the question of re-election, that's another matter. Of course, the next election committee will know exactly how long the term of office is, and there will be another election. But as for this particular term, whether it's a full term or half a term, whether it's 2 + 5 or 2 + 5 + 5, well, I think every time the election committee, as it elects the new chief executive, it would clarify these issues. But I just don't think that we need to address these issues through an NPC interpretation at this point in time. I hope there will be other means to address those issues. Leung Pik-San. And then that lady there. Leung Pik-San. Just now, a journalist asked you about the term of office of the election committee. We all know that his term is to expire on the 13th of July. Now, of course, it's very unlikely that some candidate might become deceased, but the Annex 1 of the Basic Law already states clearly the terms of office of the election committee. If you don't cater for such scenarios, you only wait for something to happen before you decide what to do with it and what should happen. Then who's to come out to address the issue? Will you ask the Legal Affairs Commission to come out and make a statement or whatever? So in that case, why don't you just address all the issues in one go now? What issues you mean? You mean the term of office of the election committee? Well, the term of office of the election committee is 5 years. There's no change. No, what about someone becomes deceased? Then the election will have to stop and there'll be no new nomination. You can only defer the election in that case. Well, I think this is rather straightforward, if you ask me. If, say, this should happen, and in the election committee they cannot exceed the current term of office, then we just need to compose a new election committee. But then their term is 5 years. Well, that's exactly the problem. We try to avoid that from happening. Now, we know that we want to constitute a new election committee. The new election committee will still have a term of 5 years. And this is not a new issue. We've been saying that all along, that there could be a vacuum that started in 2000, actually. We've always wanted the election committee to have its term tally with the term of office of the chief executive. But now there is this discrepancy, and this happened since the 2000s, not now. So that's why there's no urgency to do with that at this point in time. And also the election committee has its statutory powers to elect a new chief executive. Its term hasn't expired yet. That's why we want to make use of the current election committee to elect a new chief executive, and that is an appropriate means. And we don't want to elect a new election committee, because if its term is again 5 years, that will lead to other problems, especially in 2007. We would like to make changes to the selection method of the chief executive. We want it to be more representative and to allow for greater participation. And that may be directly relevant to the composition of the election committee. And that's why when there is no need, we really do not want to compose a new election committee.
In electrical, just now you said that you've actually gone through a lot of struggle and deliberations before you came to the decision. What sort of struggle did you go through? And is that decision contrary to your beliefs? And how do you plan to, improve the relationship with those people who are against interpretation? Many people are sensitive to resorting to interpretation. As I said, while what we're proposing is constitutional and legal, although it may be the only option, we have to consider the views of the community as well. And we also feel that recently the general public feel that there is more and more members of the public agree that there is an urgent need for interpretation. A poll taken by a newspaper showed that more and more people are in favor, believe that there is a need for interpretation than those who disagree. In my speech in LESCO, I stated clearly that the people of Hong Kong still have many views about the constitutional procedures, and that is what I meant when I said that I had to go through a lot of struggles. The lady at in the last row and the lady next to Mr. Kong.
Legal experts are, totally against this idea of seeking an interpretation from Beijing. And surely, it's hard to believe that they're all wrong. How are you going to convince people that, you're not sacrificing the rule of law for perhaps political and practical reasons?
I respect the views of lawyers, and also I respect more the views of the Secretary of Justice, who have done enormous research into this matter and have considered this matter very carefully, coming to a conclusion which I support, forming the basis of what we propose to do in the domestic legislation. We must remember also that what we are proposing to do is in strict accordance with the design of the basic law, which authorizes us, which in fact creates this mechanism to resolve disputes of this kind. This is inherent, it is in the provisions of Article 158 of the basic law. What we are doing is totally consistent with the spirit and the terms of the basic law. Nothing more, nothing less. Constitutional disputes of this kind are also inherent in most other territories having a written constitution, whether it is United States, Canada, and Australia or whatever. So it is important to realize, however we might not wish to invoke the provision of 158, there are occasions that we need to do so, and it's absolutely proper for us to do so.
Okay,
This lady. My name is LEUNG. Mr. Zhang, I remember last year you also said in this venue that you drink the water of Hong Kong, the blood flowing in the body is the blood of Hong Kong. But within a period of only 1 year, there have been 2 interpretations by the MPC, and you were the person who proposed it. How do you see your role now? Can you still guarantee to the people of Hong Kong that the blood in your body is the blood of Hong Kong and that you are not betraying the people of Hong Kong? What we're doing this time, as I have explained clearly, is that we want to safeguard the interests of Hong Kong so that we can exercise our constitutional duty. What the general public wants to see is that to have a new CE elected on July the 10th. If I cannot discharge this responsibility, I'll be going against the aspirations of the people of Hong Kong. So what we're doing now is totally for the purpose of maintaining, safeguarding the interests of the people of Hong Kong. It's not contrary to what I've said previously. Kennex? I'm from the Hong Kong Standard. Mr. Zhang, if during these 2 years the vacancy arises again, does that mean that if we're going to elect yet another new CE, then he will only serve the remainder of the term? It could be that he will only serve for a few months. In that case, There's also the CE election in 2007 up and coming. In that case, we may end up having 2 CE elections. Are you saying should a vacancy arises again? Whenever a vacancy arises, I think we would any new CE elected will serve the remainder of the term of his predecessor. Whether you have 1 vacancy or 2 vacancy arises, we will follow the original intent of the Article 53 of the Basic Law, and this method of dealing with this method will also be what we propose in the CE election ordinance. Before you came to your decision to ask for an MPC interpretation, did you talk to the officials in the mainland about this? And did anyone in the mainland suggest that you should seek for an interpretation? I reiterate again that I only have a total of slightly more than 20 days. I've tried my best to listen to the legal advice from the mainland. I've heard many legal advice from Hong Kong. I'm also very concerned about the views of LEUNG members and the comments of the media. Having heard so many views, only on Monday this week did I came to the conclusion, as I said at the beginning, that this is my important responsibility, which I cannot evade, and it's also the only option that I have, and that's why I proposed to the Executive Council this morning, and after having the support, did I make a declaration to a statement to LEUNG and also submit a report to the MPC. In the whole process, myself and my colleagues in Hong Kong, after having all these different views, we came to that decision. We allow 3 more questions. We'll let those who haven't asked any questions yet. Carrie Chan, this lady, and over there. Carrie. Mr. Zhang, I'm from the Hong Kong Standard. In answering the question by Mr. Fred Lee in LEUNG, you said that you will be seeking interpretation concerning the terms of office. Will the MPC, Eslie, follow up on other matters as well? You are not sure about it yourself. If the MPC could resolve the other residual issues as well, if someone were to apply for a GR and ask about the maximum duration of the term of CE, I think your present request for interpretation may not resolve all the issues. You're just adopting an ad hoc approach. I think it's very likely that many of our friends in the media have asked you that if the elector is not clear how long the term of the candidate is going to be, that's not very satisfactory. Why do you not resolve this matter as well? Before July 1st, will we have to face another JR? I don't think there is the need to do that, especially for the residual issues. There's not only one, there could be many. But I think we are abiding by one principle. If it is not absolutely essential, I hope we will not seek an interpretation with the MPC. I think this is the most important. What we need to deal with urgently now is to deal with tackle the question of the term of the CE. As for the other issues, either they're not urgent or they do not have any time limit. So I think in dealing with those residual issues, we have to conduct extensive consultation. If there are other ways to deal with the matter without invoking the MPC, we should do that, because interpretation by the MPC is not, even the central authorities do not want us to ask for interpretation all the time. So we will only do it when there is an absolute need. But are you clear that you can allay all the legal queries? Perhaps Ms. Leung can respond to that. I don't think there is any method that can allay all the queries from the legal quarters. Ms. Leung. The CE amendment bill only deals with the terms of the CE, one matter, that is to fill the vacancy and how long the term of office of the new CE is going to be. Any JR will revolve around this issue. You ask how many terms can the new CE serve? This is not something that will happen imminently, and the government has not enacted any legislation or come to any decision on that. When the opportunity arises, when CE may seek or re-election, we will deal with it at the time. For the time being, there is no possibility for any JR querying how many terms the CE can serve.
Now, after the MPC-SC interpretation, would it be like the 1999 right of a vote case? You'll ask the Court of Final Appeal to make a statement about the interpretation? Well, I think I'll defer that to the Secretary of Judicial Justice. Personally, I don't see the need for that. Now, some people have already applied for judicial review at the court, so we would like to leave the matter to the court. In the past, there was a case, the court made a statement, that is, the MPC Standing Committee, in accordance with Article 158 of the Basic Law, made an interpretation, and the court must not query that interpretation. That must form the basis of future judgments. So if there is to be an interpretation of the MPC-SC on this matter, the courts of the SAR will have to base the decisions on that interpretation. Now, this time, how come the scope of interpretation is so narrow? It's just about Article 53, and there's no interpretation of Article 45 and Articles 46. Do you think that's enough insurance? One question, please, at a time. No, I think I've answered that question many times. Now, it has to be absolutely necessary. It has to be that we have no other options, then we'll ask for an interpretation of the basic law. Now here, our primary concern is about the duration of the term of office, and that's a matter of urgency. And Hong Kong cannot resolve this issue before the 10th of July. There's no such possibility. That's why we believe there's a need to, we see the need to seek an interpretation from the MPC-SC. For other issues, they could be dealt with through other means, and they could be dealt with at a later stage. So that's why we've not asked the MPC-SC to deal with these other issues. Thank you. Thank you very much.